Good evening, everyone. Uh, oh, Good evening, everyone. My name is Vanessa Farkash Brahmakshatriya. I am proud to be a volunteer with CCMF Alberta, and I'm very pleased to, to represent CCMF at these legal webinars, which we do every month with Charles Fair. I'm going to give my introduction a little bit slowly just to give everybody a chance to trickle in. Charles Fair has been practicing law for over 30 years and founded Fair Legal because he is passionate about helping others, ensuring that their rights are protected and that they are treated fairly. Fair Legal deals with criminal, family, and civil litigation matters. Charles is generously volunteering his time with CCMF Alberta to deliver monthly webinars on topics of common concern to the population that we aim to serve, which means men struggling with intimate relationship breakdown and turmoil, and all of the legal, financial, existential, and mental health challenges that come with those difficult issues. At CCMF Alberta, we are committed to meeting men where they're at so that they can feel heard and validated and have conversations that matter to them. We help equip men to manage stressful situations, rebuild their lives after relationships fail, and stay connected with children. We recognize that providing mental health support for men leads to optimal parenting outcomes, a reduction in family violence, and lower rates of suicide. This is an educational offering. Please keep in mind it is not legal advice. There will be a Q&A period. You're welcome to put your questions in the Q&A in your Zoom, and some of them I can try to answer, but most of them I will read out loud to Charles during the question period. Please keep them on the topic being discussed tonight, which is alternate dispute resolution. That is mediation, arbitration, negotiation, and mediation arbitration, if I understand correctly. And please don't share too many details about your individual situation when you ask the question, because that makes it harder for Charles to answer. If you're looking for additional supports for your mental health as you navigate your legal challenges, I'm dropping a link in the chat to the programs page on our website. And we would love to see you in one of our other programs here at CCMF Alberta. And with that, it's over to Charles.
Charles is just joining us. He's having some technical difficulties, of course, today, but oh, he has just arrived. All right, it's going to take him a moment to join in. So what's the next program that is happening at CCMF?
Oh gosh, I'm I am attending the annual general meeting tomorrow, where I would like to be brought up to speed on all that has been going on, because I've been involved in just this program for the last couple of years, because I've been very busy raising my young family. So I wish I had an answer to that. I could talk about CCMF in the meantime, but I'll say that our real strength has been peer support. So we have multiple men's peer support programs, and the guys who come through there, they just rave about it, and they become volunteers, and they get help, and they help others. So please check out that programs page. Glad you're here, Charles.
You are
Oh,
muted,
you're
Charles.
muted.
Great to be here, Vanessa. I always enjoy doing these webinars because I think CCMF does a great job of providing support to men, and I represent both men and women in these kinds of disputes. Basically, anybody who needs my help. But it is really good to see that the men have support in particular. So there we go.
Right.
Now I'm going to share my screen here. And hopefully this will work here. All right, and everybody can see that. So tonight we're talking about alternative dispute resolution, but how to, basically we're going to explore some less adversarial options for resolving family disputes. And whether you're dealing with separation, child custody, other family-related matters, we're going to try to provide some practical guidance on some of these alternatives. We're going to touch on three ones tonight: mediation, collaborative law, and arbitration. There are other alternative dispute resolution options that are out there. And I'm really going to focus tonight on mediation because that, in some ways, that is the most common one. And I want to stress throughout that we're going to be doing this presentation, and I think Vanessa may have mentioned that we're going to have some questions at the end. Please remember that what I'm providing is not legal advice for your particular situation, but what I'm doing is providing some insights and maybe some public education or information that you may find helpful. It really is important to get legal advice, even if it's just a consultation with a lawyer to get some guidance on your options in what can be a very difficult dispute going through the family courts. And that includes alternative dispute resolution as well. And I don't know that we're going to have time to get through all of my slides. As you guys may realize, I do like to talk a lot, but more importantly, there are a lot of issues in this. Just to give you an idea, when I went through the mediation course as a mediator, it's a week-long course, and that's just the beginning of the training that of a full mediator will go through. So there is a lot of material to cover. I have some probably unique perspectives on mediation and collaborative law and arbitration that might not be shared with by all of my colleagues in the legal profession, and some of you may have had different experiences as well. So this is I'm going to provide some unique perspectives. I think personally that my perspectives are valuable, but they might not be for everybody. So without further ado, I'm going to move to my first slide here. So mediation, first off, as I said, we're going to talk about mediation, collaborative law, and arbitration. I'll just touch on some others at the end here. But so first off, oh, here we go. So the idea on all of these alternative dispute resolution methods is that they can be cost effective, they can save time, they are confidential, and hopefully they're going to lead to some better outcomes. And well, obviously, you see I put a question mark beside that. I have some questions about the better outcomes. If the mediation is done well, it can lead to some better outcomes. If it's not done well or the parties don't approach it properly, then they might not have as good of an outcome as it could be. So I want to start with describing really the problem underlying all dispute resolution in family law, whether that's a court-based resolution or a alternative to courts. Family disputes often involve emotional turmoil. And we often think as lawyers, we have a thing we talk about an emotional divorce versus a legal divorce. And we talk about the legal divorce, meaning when all of the legal matters, all of the legal type decisions are resolved, and you can move on with your lives, and you're satisfied that there isn't anything more to fight about. However, there's a concept that we think of that's called an emotional divorce. And if one or both parties are not really at that point where they are reconciled emotionally with the breakup of the relationship, then inevitably the legal divorce can be more difficult, more expensive, more time consuming. And so I think it's important to recognize that dispute resolution comes in that context, because mediation, if it's done well, may be able to assist the parties in coming to that emotional divorce as much as they can come to the legal divorce. The same is true of collaborative law, but maybe less so about some of the other mechanisms like arbitration and some of the court-based alternatives. Um, the important thing here is that regardless of the method of dispute resolution, it's important to recognize that the process in some ways is as important as the outcome. Because I'm just going to go back here for a second here. Yeah, if everybody has participated in the process, if you understand the process, if you have agreed with the process because you voluntarily decided to participate in it, that's especially true of mediation, then if the process is followed well, then you are more likely to be satisfied with the outcome, even if it's one that you don't necessarily agree with. You think about it, uh, oftentimes we talk about, having your day in court. Well, the day in court is really an idea that you need to be heard, and you want to feel like you've been heard. You want to feel like whoever it is that's helping with the decision making, that they have truly heard what your viewpoint is. And if they've heard your viewpoint, and if you've considered the viewpoint of the other party, then you may are more likely to agree with the outcome and be satisfied with the outcome of the process. So one of the things that's common about all of the alternative dispute resolution mechanisms is that they are, by and large, in the control of the parties. And so that's an important point to make right at the outset. So let's talk about mediation. So mediation is a voluntary process where a neutral third party, mediator, assists the parties in reaching a mutually acceptable agreement. So what's really important here is that if there is no agreement, there is no resolution. So what this means is that when you are going to participate in mediation, sorry, let's just explain a little bit more about the mediation. So the role of the mediator, that's that neutral third party, their role is to facilitate communication, to help the parties identify the issues. And sometimes you think that it might be easy, but maybe it's not. Maybe there's underlying issues that you just weren't aware of until you got into that process. And sometimes the mediator can help with that process. Um, uh, the mediator can help the parties explore a potential solution, but the mediator doesn't get to impose a decision. Now, it looks like I have a duplicate slide there. Okay, so let's talk about that mediation process a little bit. We talk about uh, helping to identify issues and explore potential solutions. So here's a little bit of background about mediation. As you've heard, I've taken a week-long mediation course as well as additional study. I'm a lawyer. That's the background I have. But you don't need to be a lawyer to be a mediator. There are mediators who come from a background in psychology. There's mediators who come from a background in financial planning. Then in business consulting may also be a source of mediators. And so, and then you can have, particularly in family law, you can have mediators that specialize in, say, parenting issues. And so that type of mediator is sometimes called a parenting coordinator. Um, uh, Parenting coordinator can sometimes impose a decision or make recommendations to the court regarding outcomes, but it's a little bit of an unusual mediation role, but it's somebody who's got experience with parenting issues. So if the mediator or if the parties need assistance with identifying issues, it would be helpful if before getting into that process, you have some idea of uh, what those issues are going to be. And that's where getting some legal advice beforehand can be really helpful. So, for example, if the parties have some complex financial holdings, they've got parties are self-employed or they've got extensive investment holdings, they've got trust funds and that sort of thing, then it may be helpful to have a mediator who has a financial planning background. The idea being here is that if people are smart about their decisions, then maybe they can reach a settlement that has financial benefits to both parties and maybe less tax, for example, is paid overall to the government. So that's one advantage of having somebody with a financial planning background. The financial planning background can also help parties identify issues because they understand things such as business valuations, and that obviously somebody who's coming from a business coach background may also have ideas about business valuations, business decision making. What do you do if the family members are both um, shareholders and directors of the family business, and now they're getting divorced? How do you deal with that business? Do you just close it up and sell off what you can, and everybody goes on their own, or is there a way to um, work out how to um, resolve the dispute, separate while preserving the business, ideally for the benefit of both parties? So that's where a financial planner or a business coach type mediator, or a lawyer that's got experience in that area, I should say. That's another source. Now, a lawyer is going to come to a mediation with a different kind of perspective. And sorry, before I'm going to talk about the mediator, sorry, a lawyer as mediator, I want to talk about a psychologist as mediator. I heard a little bit, I've talked a little bit already about, um, somebody who's an expert in parenting issues. They don't have to be a full-fledged psychologist. They could also be a social worker or just somebody who's just good with children. But a psychologist or somebody from the mental health professions may be able to help the parties with the non-legal aspects of their dispute. How do they communicate? How does what's going on help them? How do their feelings interfere with making good decisions regarding the things that are going on in their legal dispute? Um, uh, that being said, that uh, oftentimes the psychologist who's a mediator may be more oriented towards um, making sure that everybody's happy with the result and separated. But maybe, and I just put this out there, that maybe a psychologist mediator may be able to mediate the dispute such that the parties reconcile. I'm going to throw that out as a somewhat dangerous concept. I think that obviously if somebody's really intent on reconciling and the other person is really not wanting to reconcile, that can come across as stalkerish behavior, and not be treated well in the courts. But if the parties really have had a trouble in their relationship that is possible to resolve with the help of a psychologist, I think a good family law mediator with a psychology background who's open to that idea may provide for a better result for the family. And I'm not saying that I'm not trying to advocate that one should be trying to reconcile in every case. I recognize that that's just not possible. But certainly, if it is possible, then I think it's worth pursuing. Then the last kind of mediator that we talk about is that of somebody who comes from a legal background, and that can include a lawyer, but it can also be a retired judge. One of the advantages that a lawyer mediator has is that they can describe or identify or help the parties see how a court is going to view their dispute and how a court might rule about it. The lawyer who's had a lot of experience litigating things in court is going to say, oh, look, this is going to be a difficult issue to resolve here if you're going to go the court route. And so the lawyer in that case is taking on a little bit of a different kind of role in that they are trying to push the parties and really encourage the parties to settle and to resolve their differences rather than going to court. So the lawyer is coming in with some expertise about likely outcomes and really might very well be going forward and really discouraging a party from taking a certain position in the course of the mediation. And that's, I think, that may be a good thing depending on the situation, but it may not be a good thing because a lawyer really who's acting as a mediator really cannot be giving legal advice to the parties, and so as they start to go down that road of providing legal type advice to the parties, they run various risks in that. And one is that they don't really understand everything that's going on. Number two, if they are favoring one party over another, that can really undermine that the intention of mediation, which is to come to a mutually acceptable resolution that is truly voluntary, it's agreed to by both parties without undue influence by the mediator. So that's some insights on mediation. I think it's important as well to get legal advice before going into mediation. Just, and I put it this way. Um, you, you you need to be have some idea of what your options are from a legal perspective, because a mediation to be successful needs to have some give and take. There needs to be some element of compromise. And if you go into the mediation knowing what issues you may be willing to compromise on, then you may be that is, I think, a healthier way to approach the mediation rather than finding yourself in the mediation and going, oh my God, the other side wants this, and I don't know whether I should give that. Is it something that's within the range of reasonable? I don't know. I'm feeling pressured here. I just want to get this over with. I guess I'm just gonna agree or say, yeah, whatever. Yeah, do whatever you want. And that's not a good way to end a mediation. So I think getting some advice before mediation is always helpful. And I think it's also helpful to be prepared for mediation, particularly if there's financial matters or matters requiring specific information, that you come prepared with sufficient documentation. So the easy one, obviously, is financial disclosure. And I've talked about this in other webinars. It's important to have financial disclosure in every case of dispute resolution, whether that's in the court or whether through mediation. It's important to get all that stuff out of the way and communicate clearly to the other side what your documents are. But it can also apply to other issues like medical issues regarding the children. If one party is claiming that an older child may be past the age of no longer technically a child, but they're still dependent because they aren't able to go out and support themselves, then that needs that medical advice or that medical information needs to be shared with the other side, and that's as important in mediation as in any other dispute resolution mechanism. Um, I'm going to say one more thing about mediation, and this I think is also true of the other forms of mediation, that mediation is not a good option when when there's a large imbalance of power between the parties, or there is any kind of underlying abuse or domestic violence, such that somebody is saying that they're agreeing because they are afraid of the consequences if they don't agree. Um, I'm also going to say this, that it can go the other way as well. I had a client that uh, was he discovered that if he agreed to things in mediation, he would get laid that night by the other party. He was allowing himself to get manipulated quite drastically, and that wasn't leading to very positive outcomes of the mediation. Um, and speaking of outcomes, a mediator can help parties reach agreements that involve doing things that a court might not be able or willing to force the person to do. So, things like, for example, in the parenting issues, um, a court may or may not be willing to impose a regime where the parties, each of the parties, move in and out of the matrimonial home, for example, while they're and the kids stay put in the home and the parents move back and forth into the home during their time. That a judge might order that, but it's going to be much easier to order that to reach that kind of solution through a mediation process. I'm going to then talk briefly about collaborative law. And collaborative law is a legal process where both parties and their lawyers commit to resolving disputes without going to court. And you go, well, wait, isn't that what mediation is? Well, no, this is something that pulls in not a third party um, arbitrator or sorry, mediator, but rather it's where the two lawyers and the two parties all agree, look, we're going to do our best to come to a solution here. And if we cannot come to a solution, then both parties have to get new lawyers. So you want to go to court, if you're engaged in the collaborative law process, um, and you can't reach an agreement, then everybody's got to get their own lawyer, and off you go to court. Any experts that get involved in the process, and that's one of the things that collaborative law can involve. Like I said before, if you have a mediator as a financial planner, well, collaborative law, the lawyers and the parties can say, well, hey, let's bring in a financial planner. Let's bring in a psychologist to talk about parenting issues. Let's bring in a business coach or consultant to talk about our family business. That kind of process can happen under the collaborative law process. If it fails to reach an agreement, though, everybody's off the file and the parties have to start over again, getting new lawyers and new experts and whatnot to go to court. So obviously, the collaborative law process is a can result in a positive outcome if it is done well and properly. It can reduce conflict. It can provide solutions that are tailored to the family's needs. But I think I have some hesitations or some reservations about collaborative law, in that to some extent it does involve a little bit of a conflict of interest between the lawyer and the client, because the lawyer may have an interest in really they want the process to continue, and so they're going to be really leaning on their client to agree, but that pressure may not be appropriate in the circumstances. And it may be that the client has a legitimate concern that they're saying, look, if we agree to this term, this is going to be a problem. Typically it's something involving the children, and then, the parties agree to it. Now they're stuck, and lo and behold, the issue arises um, that was predicted by the client, and the client felt that they were pressured into agreeing to it because the collaborative law lawyer felt some degree of obligation to pressure their client into accepting a settlement. Now, obviously, that can happen in mediation as well. After the mediation, the parties typically need to get legal advice, and the lawyer may typically be saying, "Look, the alternatives are out there are not good. You don't like this agreement that you reached through mediation. Well, the alternatives are not good." And that can seem like pressure as well. So I'm not saying that kind of pressure is bad, but it does take some wisdom, I think, to know when there's when the right kind of pressure is being applied, and when the pressure is not appropriate. So that's collaborative law. Again, it's involves the two lawyers and the clients, the two parties signing on to that. I personally have a problem with the idea that I have to force the other side to work collaboratively. My approach to legal practice is um, I can work collaboratively with anyone. I don't have to force them to work collaboratively. If they don't collaborate, if they're not willing to engage in a collaborative process with me, then we'll take the matter to court, and we'll, again, if they're not going to be reasonable, then we'll go off to court. That's my particular approach to this, which is why I'm not particularly interested in signing up for collaborative law. I don't need to force somebody else to collaborate with me. But if they are willing to, then great. If they're not willing to, again, just off to court we go. Okay, so the last one is arbitration. Arbitration is a private process where a neutral third party, like a mediator, but this time they're called an arbitrator, they make a binding decision on the dispute. What binding means is, unless they've made some really serious error in law, that arbitration decision is final and it cannot be appealed into the courts. So the arbitrator is similar to a judge in that the arbitrator listens to both parties' arguments and can consider the evidence that is put before them, and then they make a decision. And that decision, again, is binding. The 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 arbitration process can be faster than court. Again, it's confidential. You can get an arbitrator that's got specific expertise. We've already heard about parenting coordinators, or can sometimes be given the authority to make the decisions. If the parents can't agree and a decision has to be made, then a parenting coordinator can step in and say, guys, well, you weren't able to agree. The children need a decision made, like what school they're going to go to, for example, and the parenting coordinator just makes a decision. And that's again, that really depends on the scope of what the parenting coordinator's authority has, what authority they've been given when they're first retained. So again, arbitration can apply also in business disputes and family businesses, and can be used quite well in areas of property division and financial matters, as well as we said, to parenting issues. So the uh, again, the arbitration is faster than court. It's confidential. It may be cheaper because court can be expensive, but there's some more upfront costs because you'll have to pay for the arbitrator's time, just in the same way you've had to pay for the mediator's time. So that's then there's very quickly I can talk about mediation slash arbitration, and that's where the mediator, if they can't get the parties to agree, says, fine, I'll make a decision. And I'm not a big fan of that, of what we call med arb, because mediation fundamentally requires people to come into it with some degree of flexibility, a willingness to let their guard down, willingness to acknowledge maybe the weakness in their case, as they try to find mutual agreement. They're going to disclose the things that are important to them, and the things that aren't important to them, and then to have that mediator turn around and say, well, I've heard all of this. I'm just going to make this decision. eh, Anyways, if you know that that could happen when you're going into a mediation, then I think you're going to be a little more guarded in terms of how you approach the mediation. And I think that so the med arb, I think, runs the risk of undermining some of the advantages of mediation. Now, that doesn't mean that that doesn't apply in every case. I'm not trying to say that, but it's just one of those things to just be aware of. Um, a good mediator slash arbitrator is going to be very much aware of that process, and they are it's some of those dynamics, and they're less likely to be influenced by that. But again, going back to that notion that I started with at the beginning, the process is so important. If you are confident in the process, if you're confident in the skill of the mediator arbitrator, then in fact, that you will be more likely to be satisfied with the outcome. So again, I'm going to now turn it over to questions. I think we've, oops, went too far there. Questions? Yes. So, just a reminder. I forgot to mention this at the beginning, but we do have a YouTube channel with Fair Legal, and we post we've got a lot of our webinars are already posted there. We're going to be posting this one, and some of the more recent ones are going to be posted by the end of October. So it's important to subscribe to the channel, and then you can get advance notice when or not advance notice, you just get notice when the videos are posted. So, gonna open it up for questions.
Well, there are no questions in the Q&A just yet. Ah, good. Someone's just in time saved me from coming up with a question myself. Why do some mediators only work with when both sides have counsel? Is it more effective?
Oh, now that's an interesting question. Uh, I suspect that mediator who's in that position is probably more likely to be a lawyer, although maybe not. I don't know. And I think that's because part of the confidence in the process is um, knowing what your legal rights are and understanding that when you hear something that you don't like in the course of the mediation or that you really disagree with, you've got somebody that you can kind of turn to on the side and say, hey, is that a thing? Do I have to deal with that? And the other thing is that sometimes the lawyers can help um, help the mediator focus on those things that those areas of decision making that need to be made. So they can say to the mediator, look, we've talked about it between the lawyers, and we think we've reached resolution on 4 or 5 issues. We've got 2 or 3 still remaining, and let's focus on resolving those things. So sometimes the lawyers, if they are approaching the matter in a collaborative fashion, they can provide, they can be of assistance to the mediator. And also, I think helps the mediator avoid getting caught in that legal advice role. Or if they do start saying, "Hey, look, guys, this is what a court's likely going to do," what they do is they turn to the lawyers and say, "And your lawyer can confirm this is true." And then the lawyer says, "Yeah, yeah, the mediator's right on this. Yeah, you're going to be facing a hard time if you're going to push this one through to court." So that's I think that's what the answer to that question is. So.
Hey, thank you. What practice would you recommend if your case is set for trial and you would like to try and settle prior to trial?
uh, Well, there's always a settlement on the courthouse steps. So, um, if it's already, I didn't really talk about this. So the question is when do you ask for mediation? And um, here's one of the considerations. If you propose mediation and you're already set for trial, the other side might very well think, huh, you must not have a very good case at trial, or you must be afraid of going to trial on this one. So the smart decision for me is, no, let's go to trial. So now the the lawyers have an obligation to ensure that their clients have really tried to resolve things without going to court. That's all of us have an obligation, and really it's better for everybody if we try to keep the disputes out of court. The courts are clogged with disputes, and the more we can keep them out of there. So it is a legitimate thing for the lawyers to say, look, why don't we give one last shot at resolving this? We're all ready to go to trial. If it doesn't work, we can go to trial, and we can the the two of us, the two lawyers, we're going to get richer going to trial. But hey, you know what? Let's see if we can work this out. So um, it is possible to propose the mediation in the face of trial. It has to be done the right way, I think, if you want to actually get there. That same issue can happen early on in the process of a dispute. You could say right off the bat, "Hey, let's not go to court at all. Let's just do this without lawyers. Let's go get a mediator. And if you get a good mediator, yeah, you might be able to save yourself a lot of grief down the road because you don't have to need the as much legal advice." But again, that really depends on a few things that we've talked about. One is you gotta you you gotta be willing to compromise. You've got to be willing to uh, you know do full disclosure. The and the lawyer can support that by saying, "Hey, look, you've got all the disclosure you need. This is a good decision. It's better to resolve things, even if it's not an ideal solution." So, but early on, you have that same dynamic that could be at play. The other side says, "Oh, you want to go to mediation? Hey, I guess I better go to court because that's a smart decision. I'm going to get a better outcome at court." So again, the decision whether to go to mediation or not can be tricky at times.
Okay, thank you. I think my mediator gets triggered by things my wife says. They are not neutral. How can I get a new mediator when the wife doesn't want to? Ask Charles about the myth of the neutral mediator.
Yes. I think a good mediator doesn't pretend that they don't have biases. Let's deal with first thing. Let's say a clear bias that would disqualify any mediator is that they have an interest in or a relationship with one of the parties, right? If they're having an affair with one of the parties, they're not a good mediator. if they have a financial stake in say the family business or something like that, then they are not, then they're automatically disqualified. But everybody who's involved in a dispute, the parties, the lawyers, the mediator, the judge, the arbitrator, everybody who's involved in a dispute does have uh, an emotional life, a psychological history. To suggest that none of us have any baggage as a result of that, that none of us get triggered by anything is is naive, I think. Now, does that mean that you can't be a mediator because you got some baggage? No, what it means is you've got to be you've got to be careful about how you deal with that. So you have to have that ability to kind of say, all right, fine, I'm triggering here. I'm going to squeeze this into a tiny little box and tuck it away in the back of my mind, and I'm not going to let it affect how I am handling this mediation. That's a skilled mediator. Now, if you find yourself in a position like that, you say, look, this mediation isn't going anywhere. And remember, mediation is confidential. None of it can be used in court. You could say, I don't agree with continuing this mediation. I don't think that you're particularly helping, but even if you don't have to give a reason, you just say, look, I'm not happy with this process. I don't feel confident that we are working towards an outcome that is going to be beneficial to both of us or that will be satisfactory to both of us. So I'm withdrawing, at which point the mediator has no more authority because no agreement means no resolution. And, you know, the other side might be upset about it, but it is what it is. Now, um, you know, whether you know, you have to consider your alternatives, obviously, right? You're just saying, okay, well, I'm going to pull out a mediation with this mediator, and then I'm just going to suggest another mediator to the other side. Well, how successful do you think how well do you think that proposal is going to be received? You know, you didn't like the last mediator. Why should you're just going to find somebody that I don't like is what the other person's going to say. So when you pull out a mediation, you're going to have to decide what your options are. The other thing is that, you know, there's a mediation, like any other dispute resolution process, is ultimately a human process. And there may be simply ways that you can take on a role of, you know, the more mature adult in the room, say, and ask questions in a non-adversarial way, raise issues, change the subject, do things that demonstrate that you are in control of the emotional tone of the mediation. Everybody should appreciate that. Or if they don't appreciate it, or if you don't do it very well, then they pull the plug on the mediation and off you are to some other option as well. I think that it's important to recognize that in any of these processes, you don't lose your the word I think is agency. You are in control of how you react to the mediators getting triggered by something. So remember that. And so there may not be as dire a circumstance as you might believe. A good book, and I wanted to mention this, a good book that kind of deals with this kind of thing is called Never Split the Difference: How to Negotiate if um your
Like
life
your life depends on it.
yeah, there we go. As your life depends on it. That's right. It's written by a hostage negotiator. So you think of a lot of family situations, one of the parents might be keeping the kids hostage. And so it's a great book to read. And it's not about bashing the other person. I think if you read that and you go into a mediation with some of the approaches that are recommended in that book, you might find it changing the dynamic of the mediation without changing the mediator. So there you go.
Yeah, I'm just reading that for the second time now, Charles. It's a gem for many areas of life.
Yes. Oh, I think it is. And you know, I mean, ultimately, it's about understanding where the other side is coming from, and not trying to force uh, something that you cannot control. And does that sound, Vanessa, does that sound like a fair statement of the a one-line summary of the book?
I suppose, but it's incredibly effective as well. It's not just about acceptance.
Yeah, right.
Okay.
I mean, yes.
Well, no, we can, talk about it at our book club, Charles.
Yeah.
So, my ex and I attempted mediation through the courts. It wasn't successful. She had filed for a docket court hearing and is referencing the discussions had in mediation, though it was explained that this was confidential. Is this a breach of confidentiality?
Yes.
That was a very short answer.
It
Stunned.
is. And unfortunately, it happens more often than it should. And I think the people who do it need to be called out for it. And now a good judge in now in docket court, it doesn't really matter a whole lot. Okay. And the reason why I say that in docket court is because the docket court is a triage court, and having some idea of where the parties are in the alternative dispute resolution process may help the triage judge, the judge running the family docket court, make a good decision about what the next step should be, whether that's a court-based resolution system like the early intervention case conference, or a Rule 410 case conference, or a judicial dispute resolution, or sending the parties off to morning chambers. The decision of the family docket court is not based on the contents of what was said in mediation. So, you know, it happens, and it doesn't. I don't think it has a whole lot of effect in the family docket court process, other than influencing what the next procedural step is going to be. Now, if it gets referred to in affidavits and in morning chambers or in special chambers hearings or a trial, that is definitely uh, needs to be disregarded by the court, and there are ways of doing that.
Sorry about that. You mentioned the importance of preparation for mediation. As my former partner and I are going into mediation, there is a defined benefit pension that needs to be shared. If we want to come to an agreement related to this in mediation, which party is expected to get an evaluation done by an actuary of the pension owner, or the other side?
Um, well, the here's the uh, there's different kinds of pensions, and you've mentioned, it sounds like it's a defined benefit pension, and those are the ones that are most difficult to value. And the valuation process involves a number of assumptions and mathematical calculations based on those assumptions that are essentially best done by an actuary. So the person who owns the pension holder, typically will have a valuation, what looks like a valuation that has been prepared by the pension administrator, and that almost always understates the value of the pension, especially if it's a defined benefit pension. So they, I think that as a practical matter, then the party that is seeking to have a different valuation is the one that should have the obligation of going and getting that valuation. There are actuaries in town that won't charge a whole lot to give a verbal opinion that can be of assistance to the parties, and you can even agree to jointly retain a pension evaluator who may in fact act like a subject matter expert in terms of mediating the dispute as well in the right kind of circumstances. So, unfortunately, you're trying to mediate a solution. I mean, it's a topic of to be resolved. Who's going to pay for it? Who's going to be going to get it? And is there a way to do it that is less adversarial than another way? So there you go.
If the other party alleges domestic violence, is there still an alternate dispute resolution process for family court and parenting that can be used instead of going only to a trial prior to those domestic violence issues being resolved?
I think it really does depend on the nature of the allegations and yeah. So I'm not going to say it's impossible. I mentioned earlier that if there is uh, certainly if there's real domestic violence, then it is problematic. If if the domestic violence that's being alleged is not real or distorted in some way, then it may well be that some alternative dispute resolution mechanism, say with the assistance of a psychologist, may be of assistance to the parties. Um, but fundamentally, it does create it is difficult, even when they are just allegations. I think fundamentally it's difficult to get to a resolution if somebody is claiming that. It undermines the integrity of the process. And so unfortunately, um, the the only way to really deal with it may well be to go all the way through trial, and it's not effective to use an alternative dispute resolution mechanism, although there are ways of uh, I'm going to say massaging the situation to make it more appealing to the other side to go to alternative dispute resolution than going to court. But those are trade secrets.
Mhm. My lawyer recommended a mediator who has 30 plus years of legal experience as mediator, arbitrator, and parenting coordinator. In addition, has been appointed to King's Counsel in British Columbia. How do I know if this mediator would be a good fit for me?
Um, well, have a discussion with your lawyer about who they are and what they're and why the lawyer thinks that they are going to be a good fit, and I think that's a legitimate um, discussion to have with the lawyer.
I think this will be the last one. I have filed a notice to mediate, and my ex keeps delaying the mediation and has asked to be rescheduled twice. What should I do?
I presume that the notice to mediation is pursuant to an agreement or court order to that effect. In which case you go to court and you get an order compelling the mediation and see what they say, Um, I, you know, I I don't those kinds of orders are made and they it's an odd kind of order when you think about it because you're saying go off and agree, but what if you really can't agree? So, I think it's important to try to understand where your where the spouse is coming from who keeps delaying. Is it a legitimate reason for delaying? Is it a financial issue? Are they having trouble coming up with their share of the mediation fees? I think it's worth exploring that in more detail.
Okay, that brings us to the end of this educational offering. Charles, as always, thank you so much for joining us and giving us so much insight and content. And please look in the chat, uh, participants, to find the Fair Legal YouTube channel where you can watch all of the sessions of this webinar series. There is a lot of really great information, and I hope that you can find what you're looking for to help ease your way with your own legal troubles or the troubles of those you love.
Charles, I'm also going to mention that there were two books you wanted to give out today. I'm just putting that in the chat as well. Feeling good together?
Not free books to send out, just the free references to the books.
No, just there were two books to
Recommendations.
mention.
Recommendations. Yes. Yes. And one of them is in the chat there. It's Never Split the Difference by Chris Voss. The other one is a somewhat unusual one. It's called Feeling Good Together: How to Make the Troubled Relationships in Your Life Work by David Burns. And that one is uh, it's not about reconciling as much as it is about understanding how you may be inadvertently contributing to the issues. It was the first self-help book I read that didn't leave me with a list of everything that my ex was doing wrong, which was plenty, but that wasn't particularly helpful. At least I thought it was plenty.
That that's a great recommendation. I might have to check that one out myself. And again, thank you. Any concluding remarks?
No, just again, and if somebody does want to get legal advice, go through CCMF. You get you register through them, and they send the referral on. You get half an hour for me at for free, and normally that doesn't. If you go directly to me, it costs. That's just the way our system works. So that's a little bit of an advantage there. But again, just another reminder about the YouTube channel as well. Subscribe, and yeah, you'll notice. I think it's in the chat. Okie dokie.
We're all in
All
the
right.
chat.
Thank you. Good
Thank you.
night, everyone.
Thank you again, Vanessa.
Bye bye. Thanks, Charles.